Hello everyone, welcome back to the channel. Hopefully you guys had a good New Year's Day. Didn't get too drunk. I enjoyed mine. I went to a Lindsey Sterling concert, which will be like the fifth one I went to in like 4 years. My thing though, got my daughter into it. Appreciate anyone who participated in the webinar for the tax management, foreign income. Hopefully you guys learned something. If and when you guys have questions, feel free to ask. Today, it will be part 6 of my videos, which it looks like we're about a little bit less than halfway. So I'm thinking this is going to be like 12 videos in total. I know it's taking a lot, but I don't feel like reading 100 pages in one setting, and it's going to be a 2-hour thing. So for each video, just to cut it down on the number on videos. But today will be section 5 of American Jurisprudence on Business Trust, volume 13. And it'll be trustees, officers, and agents. All right. So section 43, generally and eligibility. Generally speaking, and in the presence of statutory restrictions, in the absence of statutory restrictions, any person may be a trustee of an express trust who is capable of confidence, of holding real and personal property, and of executing the trust, subject to the limitations placed upon its powers by its own charter or by statute. A corporation may hold property in a trust and may act as a trustee of a business trust. But this statement right here, it's up to you. They can, if it's allowed. Since it's a corporation, the statute, the Constitution or the statute of the state of the corporation, they allow it or they don't allow it. With you, when your trust or our trust, right, the one anyone creates, it's your choice as a grantor. Like mine, I specifically restricted all trustee to be natural persons. I don't want artificial persons. The ownership of shares in a business trust does not disqualify one from becoming a trustee. Indeed, some business trust instruments expressly provide that the trustees may own shares. However, this rule is subject to the general principle that a sole beneficiary cannot be the sole trustee. That's the doctrine of merger, which I highly recommend. Just do a quick Google search and Wikipedia will give you a good definition. And it has been held that where all of the shareholders in the business trust are trustees and all the trustees are shareholders, so that the two groups are composed of identical persons, there can be no valid trust. Absolutely true. However, this defect or disability is cured by subsequent acquisition of shares by persons other than trustees, which you just made one side lopsided, right? The supplement and footnotes, again, they keep repeating American Law Review, 3rd edition, volume 88. In the old book, the one they will continuously recommend, right, is American Law Review, volume 1. First edition, and volume 156. In some instances, banks have been named trustees, of course. I highly recommend reading this case right here. Commercial Casualty Insurance Company versus Pierce. It's an Illinois case, but it dealt with a partnership, a father-son construction partnership that they dissolved. Well, they transferred the property in the partnership into trust. They dissolved the partnership. Both the son and the father were trustees. The father was the only beneficiary. At no time did the father have total control by himself or powers in any regard. So this is a good case to show where it's a father and son. The father retires from trustee. He's still the beneficiary. And then the daughter takes over with the other son, along with the other son. And that's it. Like, that's the end of it right there. But this is a good case because there's something that I still am trying to comprehend from the case. In the case, the only statement that the judge says is that the shares that they received, right? Because you got to remember, it's a partnership creating the trust, right? Because them in their personal private capacity, they cannot transfer partnership assets to make a trust. They have to do it in their capacity as a partnership. Okay, well, that transfer was not a gift. They received shares for that transfer, but then they gave it to the trust for whatever that is. I haven't found much information on that. It's kind of disappointing, but I would like to know what type of transfer that is. I'm guessing it's a gift. So it can't be an exchange because they didn't receive nothing back. So it has to be a gift where man, that's the only thing I got is it's a gift. And it's an irrevocable trust. And the powers, there was no powers of revoke to revoke the trust or anything, so it was a completed gift. And they didn't bring no issue of that fact. So it's like it has to be a completed gift. Right? The legality of how it was created was not an issue. In such a situation, the legal and equitable titles of the property of the trust would come together in the same persons, which generally terminates the trust, which is a given. Now look at that's a trust principle, section 88. And they're telling you to go see Trust, American Jurisprudence. That's volume 76, which I might do, but might do videos on that, or I might do one on Scott on Trust, right? Because it's a little bit shorter, maybe, but we'll see. Section 44, status. They give a annotation for that, and they just tell you to go for American Legal Forms, Jurisprudence Legal Forms, Volume 3. In a typical Massachusetts or business trust, title to the property is held by trustees, and the business and property of the concern are managed by them for the benefit of shareholders. In making contracts for the trust estate, in conducting its business, and in holding them and managing its property, the trustees act as principals and not as agents or representatives of the shareholders. The fact that the individuals having charge of the management of the business and property of the trust are designated managers does not prevent their being treated as trustees, nor does the mere use of the term trustees, right, just a word, it's all about the powers and the office itself, the characteristics of what makes up this word, right, necessarily fix the legal status of the persons to whom it is applied as trustees, as distinguished from partners. So the reason why this is important right here, say you either become your own manager, right, or you hire managers. If you give them as trustees, not the grantor, if the trustees give these managers administrative powers, these managers will be construed as trustees. You have to give them ministerial powers. No, they cannot have no decision-making powers, no substantial decision-making powers. That's what they cannot have. Supplement, same thing. Denying status as trustee, they give a pleading and forms. It is a template. Footnotes. They got provisions, American Jurisprudence, Legal Forms, number 3. Pleadings, it's 20 American Jurisprudence. The other one was 5 American Jurisprudence pleadings forms. Contracts with regard to the rights and property affected by trust are the contracts of the trustee. He, in person, is liable upon them. He is not acting as representative or agent of another. He is acting for himself, but with fiduciary obligations to others. Now, because you are the principal, right? One of the principles of trust law, not business trust law, right? The trustee is held liable through the door. But because of the flexibility of trust law, you could limit the trustee's liability and make it and have the trust answer for his acts that are in accordance with the trust, right? If he did something that's not, right, that then no one can impose that the trust pay for what he recklessly did. Unlike a corporation director who, if he acts apart from the board, may function as an officer or agent of the corporation, a trustee of a business trust acts in the single capacity of principal in performing the usual duties of a trustee. I have not read this case, Loring versus United States. I don't know what it's about. It's a federal case. Might be new. Well, it can't be that new because it's federal supplement. It's the first edition. In some trusts, however, the trustee merely holds the legal title to the trust property, and managers designated in the trust instrument carry on the affairs of the trust. And that's a case that I still have not read. I thought I saved it. Because it'll be good to read this to the extent, okay, what powers did they give these managers to make sure that they are within their scope as just being managers? That's what I would be looking for in this court case. Section 45, designation or election, right? Term of office. The instruments creating business trusts usually, and remember, as we're reading this, apply those principles that we learned earlier, in the other sections about too much power or not enough power or whatever else. Those things do, man, they'll place liabilities. There's no other way of putting that. They'll place liabilities. Even though they're saying that they could do something, granted, yeah, they could. Why? Because it's a contract. You, as the grantor, could get them to do anything that's not contrary to public policy. But the thing is, though, if you do it, what happens? That's what never is answered. The instruments creating business trusts usually name the original trustees, fix their terms of office, and provide for the manner in which their successors shall be appointed or elected. In some instances, it is provided that the trustee shall hold office for life, and that upon the death of the trustee, the survivor shall succeed to his title and duties. So that's, your kids. Survivors, they use survivors for it. I would think this is more probably similar to heirs, right? Just like a beneficiary. If a beneficiary dies, the shares are his personal property, right? They get transferred to the next person, either to his executor during the period of that transaction, the transfer, or when it goes to the beneficiary. Nonetheless, they succeed on that title and partake, if any, duties, if there are any. But mostly it's going to be restrictions and whatever rights provided. Often the surviving trustees or the shareholders are given the power to fill vacancies in the office of trustee. And many trust instruments limit the term of trustees and provide for periodic elections of trustee. All right, well, you got to remember, right, power to the shareholders. Another great thing. Where the trustees and shareholders are given concurrent power to appoint trustees to fill vacancies, the exercise of the power by either group deprives the other group of the power to make an appointment for that particular vacancy. In such case, the appointment is deemed to take place at the time when they designate a successor and not at the time when the appointee qualifies by formal acceptance of the office. A court of equity has jurisdiction to entertain a suit to confirm the title of a duly elected or appointed trustee and to compel the co-trustees to recognize the legality of the plaintiff's claim to that office. This would apply for sure in the future. You're long and dead and there's no one around to interpret your contract anymore. And there's new trustees and people don't want to honor one trustee or whatever. Well, that trustee can go to court. That is a principle of equity that they could do that. That's one of the basics. Section 46, compensation. Instruments creating business trusts usually make provision for the compensation of trustees, in which case the rights of the trustees with respect to their own compensation are governed by the terms of the trust instrument. A provision in a trust instrument for the allowance of a certain percentage of the profits of the trust business as compensation to the trustee does not disqualify him from acting as trustee. The only thing that I would probably read on this case, right, is he's receiving a percentage of the profits. This is income. There's only one class of persons who benefit from that, and that's the beneficiaries. In other words, he should be getting compensated from the principal and the capital, meaning the income did not go to the beneficiaries and it gets accumulated in the trust. You use that for your expenses, not the profits, not the income. Well, you could use the income, which I have provisions for that, especially like court cases and fees, attorney fees. It comes from the income first. But nonetheless, it's the concept of receiving income, right, which is supposed to only go to the beneficiary. How that would affect, only one way to find out. Let me see, that's footnote number 12. Let's see what they give. They give a couple court cases, but they got a limitation of salaries to a certain percentage of all monies received by the trustees has been held to refer to gross income and not in net income. Dunbar versus Redfield. I think I gotta read that again. Oh, I gotta remember this. And under the trust instrument authorizing the trustees to receive such compensation for their service as they deem reasonable, it is not improper for them to pay themselves a reasonable commission on shares of the trust sold by them. So if you have a trust that you're trying to make into an investment trust, where you're getting shareholders to invest money, right? Well, they're taking a chop out of the sale of those shares. However, a provision of the trust instrument entitling the trustees to compensation from the trust estate does not give them a lien in receivership proceedings for the value of their services superior to that of a mortgage on trust property executed by them. They basically say they can't get paid first, that there's a lien first on the trust property before they could put, but they're putting a lien on receivership proceedings. So well, they didn't say they can't put a lien on receivership, right? On the receivership proceeding. They just said it's not superior. I would go on that interpretation instead. They're just saying it's not superior. There was a prior lien first, and anyone who studies commercial law should know that too. In the absence of a provision in the trust instrument fixing the compensation of the trustee of a business trust, he is entitled to reasonable compensation for his services, and it has been held that an agreement will be implied to pay him a reasonable compensation out of the trust funds for services rendered by him to the trust. What amounts to reasonable compensation depends, of course, upon all the circumstances, and the fact that trustees or managers are also beneficiaries does not affect their claim for services. So that's managers. You could be a manager. Let's see, that's 17. Holding that compensation received by a trustee was not unreasonable under the circumstances. So whatever these circumstances were for Todd versus Ford. We're starting with nothing. The trustees of a business trust have an issued capital of $300,000. In the course of 12 years, paid out in dividends about $2 million and accumulated physical assets worth about $500,000. An average compensation paid to the trustees respectively was $1,200, $962, and $842 a month, was held to be reasonable. And that's that Dunbar Redfield case. I remember this part. I don't remember that other part, the gross income, net income part. And the fact that trustees are the compensation of trustees of a business trust who are performing the usual duties of such trustees has been held not subject to Social Security contributions because the trustees cannot be deemed as employees, which is true. With what I wrote up for myself, right? We don't get paid. The trustees don't get paid. We'll get paid for managerial services though, but not as trustees. A provision of the trust agreement requiring the beneficiaries to pay the costs, charges, and expenses in connection with the management of the business trust has been held to render them liable to the managers of the business for a reasonable compensation for their services, although there was no specific provision for compensation for the managers. Pointing out that trustees of a business trust are principals, not agents, and even when acting individually, cannot be regarded as agents of the trustees as a unit, since the requirement of unanimity, well, I know that's unanimous, right? But unanimity negatives the right of the unit to control any one trustee. Right of reimbursement or to indemnify. Section 47. The trust instrument may specifically provide as to the expenses and reimbursement of the trustees of a business trust, and even in the absence of such a provision, the general principle of trust and the trustee is ordinarily entitled to reimbursement from the trust estate for all necessary and reasonable expenditures made in the execution of the trust is applicable to business trust. Where a trustee of such a trust has acted in good faith for the benefit of the trust, he is entitled to indemnify himself for his engagements and liabilities out of the trust estate in his hands, and for the purpose he is entitled to a credit for expenditures on his account. So too, shareholders suing a trustee for an accounting for profits are chargeable with losses incurred by the trustee in good faith. In order, however, to be entitled to reimbursement for expenses incurred on behalf of the trust estate, the trustee must make a definite showing of the amount and the constitute items of his claim. But it's not just that his act, right? These are your receipts, right? But the thing is, it's the act itself. It has to be pursuant to benefit the shareholders. On the other hand, property of the trust estate cannot be used to reimburse trustees for losses or expenses incurred by them, unless they have exercised good faith and common prudence, and they are not entitled to contribution or indemnity from the shareholders for a liability incurred by the trustees in violations of the trust instrument. Thus, the right of a trustee to reimbursement or indemnity is lost where his personal liability resulted from his failure to insert, as required by the trust instrument, a provision exempting the shareholders and trustees from personal liability. Let's read that again. Thus, the right of a trustee to reimbursement or indemnity is lost where his personal liability resulted in failure to write down in your contract, or actually the trust instrument in this case, that the trust instrument didn't have it, that the shareholders and trustees were not to be held liable, and you look to the trust. So he couldn't get reimbursed because of that. The annotations. Coupled with failure to secure the concurrence of his co-trustee. Holding that trustees as sureties on a note executed for a trust without stipulation against shareholders' liability cannot assert primary liability of shareholders. That's volume 156. Section 48, resignation, removal, or replacement, death, or disability. Although it is said that a trustee who has once accepted and entered upon the execution of an ordinary trust cannot resign or renounce the trust without the consent of the beneficiaries or of the court, the instrument creating the trust may give him the right to resign. Where the trust instrument gives trustees of a business trust the right to resign at will, they do not violate their duty by entering into a contract to sell their interest in the trust and to resign as trustees so that others may be elected trustees in succession. And like I said, it's elastic as a contract. Traditionally, ordinary trust, right? The principles, you cannot resign without permission first. Not with contract. Contract ultimately is the versatility of contracts. Where the trust instrument gives trustees of a business trust the right to resign at will, they do not violate I already read that. The instrument of trust sometimes contains provisions permitting the removal or replacement of a trustee by the shareholders or other trustees. A provision authorizing the removal of trustees by the shareholders is valid and effective, regardless of whether the organization is treated as a trust or a partnership. And where the power of removal is conferred, it seems that the court will not, in the absence of fraud, review the action of the shareholders in removing the trustee at a meeting regularly called. And this right here only happened because the shareholders were given that power, right? So now that they have that power through the contract, they remove the trustee. Well, the judge ain't even trying to look at it because why? The contract said they could do it. So, and there was no fraud, right? So the trustees needed to prove some type of fraud on the behalf of the shareholders before they were even able to look at it. Nor may indirect means be taken to circumvent the provisions of the trust instrument governing the manner in which the trustees may be removed. Where the trust agreement provides that the trustees shall hold office until it becomes vacant on account of death, inability to act, or resignation, the trustees have no power to remove one of their number so long as he attends the meeting and does not resign. But a court of equity has power to remove the trustees of a business trust upon the proper showing of fraud or unfitness, and to appoint other trustees in his stead, even though the trust instrument does not reserve to the shareholders the power to remove the trustees. So what's important about this statement right here? The shareholders are receiving a protection from the principles of equity that were incorporated as a statute. And they use that statute to remove the trustee or to appoint one or whatever else. And this is what's important here. The contract, the indenture didn't say nothing about the shareholders to do this, to give them direct power. Instead, they gave the courts gave them indirect power. The meaning that you could bring us something that we might be able to look at for you on your behalf under the principles of equity. It has been said that the death of a trustee of a business trust ends his interest under the trust agreement. Upon the death of a trustee of a business trust and the failure of the proper persons to appoint his successor, a court of equity may appoint a successor with the same powers and duties as the original trustees, and the trustee thus appointed by the court takes title to the trust property, subject to the same conditions and equities to which it was subject in the hands of the original trustee. But this is all based on what? Failure of the proper persons to appoint his successor, right? If there's a failure, that means it's in the trust instrument, and the trustees didn't act, or whoever the persons were, right? Proper persons. Could be a protector. So you got footnotes, annotations. A pooling agreement was held to be invalid insofar that as it would permit the owners of a mere majority of the pooled shares although constituting less than a majority of all the shares, to remove or replace a trustee in violation of a provision of the trust instrument for such removal or replacement by the owners of a majority of the shares in the trust. So let's read this. A pooling agreement was held to be invalid insofar as it would permit the owners of a mere majority of the pooled shares, although constituting less than the majority of all the shares. So the people who are participating is less than the majority of all the shares in the trust that represent the trust. To remove or replace a trustee in violation of a provision of the trust instrument for such removal or replacement by the owners. So there is a power for the shareholders to remove a trustee where it's the majority. But the majority of this agreement is not the same as the majority in regards to all the shares. So they held that invalid, which makes sense, right? Part B, this is powers and functioning, right? So this is another section. This is going to be section 49 generally, right? The instrument creating a business trust is to be looked to in determining the powers and duties of the trustees. In addition to the statement of the objects and purposes of the trust and the character of its business, which of itself indicates a broad outline the activities and duties of the trustees, such instruments usually contain special provisions defining these powers and duties in various degrees of particularity. The powers of trustees of a business trust are limited to those conferred by the trust instrument and those necessarily implied therefrom, right? So it's one's written and the one's implied. Like, what was that court case? It was the power to sell trust property implied also the power to withhold the sale of the property. That's an implied power. Oh man, I forgot what the name of that court case was. And in order to bind the trust estate, the trustees must act within the scope of the powers thus conferred. So to minimize their own liabilities, right? A person dealing with the trustees of a business trust, knowing them to be such, is bound to ascertain the extent of their power, and having knowledge of their actual authority, cannot rely upon any apparent powers. The fact that certain ventures undertaken by the trustees were not successful is no indication that the trustees exceeded their authority therein. You got supplement, same thing, legal forms. They're giving you templates to how to write up provisions for vice presidents and presidents. Necessity of good faith of trustees, presumption in favor of grant of powers to trustees, real estate investment trust and syndicates. 15 American Jurisprudence legal forms. Damn, do I have this? Well, here, right here, I wrote this, like, without knowing this, right, is I wrote this, right? Presumption in favor. For whatever this means, right, the necessity of good faith, right, there, because you have to be deemed that you're working in good faith, there has to be a presumption that the powers, that the grant of powers are in favor for you. And I wrote this based on seeing it everywhere that I read. Like you name it, I'm finding it in trust indentures going back 100, 120 years, 130 years, and so forth. That's where I based mine from. I never found, this is legal form, so it doesn't really give the answer, right? But I never found the reasons for this outside of my own interpretation, right? Based on good faith. Just like when you go to court now, right? What happens? You're presumed somebody. You're presumed to be some form of a person, right? Until you what? Show otherwise, right? Well, that presumption is in favor for them, not for you, but for the court. You know what I'm saying? That grant of power rests with the court. But nonetheless, it's a favor in favor for them. The trust instrument is best evidence by which to prove the power of the trustees. These are annotations, footnotes. Footnote 20, involving Florida law. Express authority to mortgage carries with it power to sign and deliver obligations of the trust to secure with which the mortgage is given. So it says, so here, this is the rest, the other stuff are implied, right? So this is an example. Express authority to mortgage. That's the power. Carries with it the power to sign, deliver obligations of the trust to secure which the mortgage is given. Right? That means sale of property, whatever it is, delivering of property, bailments, you name it. Power to make contracts for sale of trust lands implied from purposes of trust. Delegations of formal execution of mortgage securing debt. Let's see, footnote 20. Which one was that? Right here. The powers of trustees of a business trust are limited to those conferred by the trust instrument granted, and those necessarily implied therefrom. So, yeah, it's all implied powers. Right? There's 20. All those things are implied powers. Okay, here's trust instrument provision. 3 American Jurisprudence legal forms. Implied powers. A manager of business trust is charged with knowledge of the contents of the declaration of trust under which the business is operated, which is a given. Your manager that you hire needs to know your law. You fuck up if you don't. Section 50, manner of functioning by trustees, unanimous, joint, or individual action, right? I prefer unanimous, or I think joint. No, well, joint is together, right? And unanimous is like everybody confers and agrees at once, right? Joint is that they have the power together, and one could refuse, right? Or both refuse here, or both approve. Here, one or the other could refuse, and this one by himself, he could do what he wants. The general rule that there are co-trustees of an ordinary trust, they all form but one collective trustee and must execute the discretionary duties of the office in their joint capacity. Now, this is what I have. Why? Because I do not want single liability or powers in one person that could, make things liable, persons liable, trustees, beneficiaries, whatever it is. So I go with the principle of trust law. And that's where they all are together collectively and agree together. Now it's jointly though. I don't have really unanimous, like a unanimous thing. I have it where a quorum of trustees, right, must approve it. So if my quorum is 2 trustees and there's 3 trustees, well, 2 is the only thing that's required, which is a majority. But the thing is, it's joint. They all have to make the decision together. It's not one person making it, and it does not get approved or denied based on unanimous decision. Applies to the trustees of business trusts who constitute a board and must act as a unit in the absence of a provision to the contrary of the trust instrument. It has been held that the trustees can act only as a board assembled and not through the individuals who happen to compose such board, unless the trust instrument provides otherwise. And they're going to keep repeating that. However, the trust instrument may authorize action by a majority or by a specified number of trustees. And it has been held that the trustees may delegate to one of their numbers certain duties vested by the trust instrument in the trustees generally. So a trustee could give their power to another trustee if you, of course, allow it in your trust. that the trustees may constitute one of their number and that the trustees may constitute one of their number the president and general manager of the trust with power and authority to execute and hypothecate notes, and that authorization of a single trustee to enter into a contract under a trust instrument, providing that the majority of the three trustees should rule, may be established or shown indirectly and by the conduct of the parties. Under the trust instrument, expressly authorizing action by one of the trustees in connection with certain matters, providing for action by the trustees in other cases, the participation of all trustees has been held necessary to bind the trust estate on a contract not relating to a matter on which a single trustee is authorized to act. One dealing with a single trustee with knowledge that his authority is limited is bound at his peril to ascertain the extent of the trustee's authority, and a provision of a trust instrument excusing persons dealing with the trustees from the necessity of inquiring into the authority of the latter has been held not to validate a contract made by a single trustee, without some explanation of the failure of the other trustees to join in the contract or an authorization or ratification thereof by them. The trust instrument provisions with regard to the officers and agents of a business trust and the delegation of authority to them or to an executive committee of the trustees are discussed in the following section. This is in the following section that's coming up. So this is the supplement, and you got monthly meetings, quorum, action. This is number 4, legal forms. Like a footnote 5, that's the one that they said the power that's in the original trustees. That's section 296 on American Jurisprudence on Trusts, which you all should have a copy of if you guys follow my Telegram group. The trustees are not merely agents who act independently by one of another. They constitute a board, and they can act only as a unit in the disposition of any good business of the trust which requires exercise of judgment or discretion. Wherein the attempted approval by the individual trustee in another state of a contract may be made by disqualified trustees was held not to give any validity to the contract, which that's a given. Under a trust instrument expressly providing that it shall not be necessary for trustees to assemble formally, so meaning a meeting, right, for the purpose of conducting the affairs of the trust or exercising their power. They may act and vote by telephone. Appointment of a trustee to fill vacancy. What's important here, right, is this is still an act of the trustees. So it's important that you document it in your minutes, even if you didn't have a meeting. You specify things like that in your meetings journal or whatever you want to call it. Where the trust instrument provides for action by a majority of the trustees, one trustee can, acting alone and without authorization or ratification of other trustees, cannot bind the trust estate by his contract. A lot of these things are given. You can see where they're messing up at, where they're doing things that they shouldn't or whatever. It all depends on the contract, though. What powers did the grantor give the trustees, or how they are supposed to execute, right, their powers. Trust instrument empowered the trustees to deal and use the trust properties and monies to manage and conduct the trust in any manner that they deemed fit, to execute and make all agreements and instruments, and to do anything else properly incident to the trust purposes. This is, I would want to read this case, which is this one. It's a Texas case, right? But the thing is, this is it right here. This is broad. This is broad power. Like, you could put this in a document, right? But at the same time, odds are in other provisions, you restrict this. You restrict this with, with whatever other limitations. Holding that the question of such authorization of a single trustee is for the jury and not for the court. California case. Right, Section 51, delegation of powers, appointment of officers and agents. And they give a footnote. Let's read that footnote first. So this is Phoenix Oil Company. Holding that trustees were entitled to mandatory injunction against one whom they had attempted to appoint general manager, requiring the latter, the manager, to turn over to the trustees the books, money, and also other personal property belonging to the trust. Well, yeah, it's an agent. What does an agent do, right? He works for the principal. He's not the principal. Where the trustees of a business trust are charged with the duty to manage and control the trust business, they cannot divest themselves of that duty. Thus, where absolute control and management of the trust property and business is vested in the trustees, it has been held that they cannot appoint a general manager to control the affairs of the trust to the exclusion of the trustees themselves. Of course not. A manager is ministerial. He's an agent. On similar principle, power vested in a designated officer of the trust to make contracts for the sale of trust lands does not authorize him to delegate to another the power to do so. Especially if you write that, right? Of necessity, however, the trustees may originally delegate ministerial and non-discretionary duties to others and may employ agents and servants for the performance of acts of this nature. What do they say? Ministerial and non-discretionary duties. Thus, after arranging the terms of the loan, the trustees may delegate to an attorney in fact, the formal execution of a mortgage securing the debt. In this regard, the powers of the trustees may be broadened by provisions of the trust instrument. For example, the trust instrument may authorize the trustees to create a board of directors or an executive committee to exercise certain designated powers of the trustees in the management of the trust affairs. So that's something that one should consider, right? You know that the trustees, to not be construed as some corporation, association, partnership, or whatever else, right? They have to have ultimate control of everything, right? It's a substantial decision and discretionary powers, right? Can't be delegated to managers. But in this case, they're telling you also for creating a board or directors or executive committee, right? Those are still agents. They're not the board of trustees or nothing, right? These are still agents. You give them specified shit, designated powers. It has been said that trustees cannot, without the consent of shareholders, appoint agents to represent the latter. However, the shareholders may subsequently ratify or approve an unauthorized appointment of such an agent so as to be bound by his acts. Like I said, this is a power that they gave shareholders. Understand that most of the stuff that I'm reading, right, if they seem like a negative, dude, that's because the contract let them do it. There's no other way of saying that. It's not the judge doing this. It's the contract that's doing it. Footnotes, I already read a couple. Provision for executive committee. Section 52, ratification or acquiescence by trustees. So this is, accepting the trust or whatever. The trustees may bind the trust by their ratification of an unauthorized act on behalf of the trust. Thus, a contract within the authority of the trustees to make may be adopted by the trustees or a majority of them, although it was not properly executed or was made without formal authority. And it has been held that the ratification may be by acquiescence and need not be by formal act at a meeting. If I had to guess here, right, just like how some have learned about silence of acquiescence, right? Well, it's the same thing here. Now, some act has been done that was not properly authorized or ratified, right? But if you don't act, or another trustee acts against or for it, right? Or, well, in this case, say against it. Well, then your actions are ratifying the approval of that. You know what I'm saying? Is your actions determine a lot. Like, if something happens, right, and you find out about it, and then you're like, oh, well, let's find out and wait and see what happens. And you wait 3 days and something happens, you don't like it. Now you're against it and you're saying it was unauthorized act. Well, dude, that act of waiting to see what happens after you were told just screwed you. Further ratification by the other trustees of acts of a single trustee can supply the unanimity required by the trust instrument of the acts of the trustees, and such ratification may be inferred from knowledge, of course, of dealing with the failure to object to it. There you go, right there. And such ratification may be inferred from knowledge, of course, of dealing and failure to object to it. Can't make that shit up. Although the trust instrument contemplated action by the trustees at regular meetings. Although the trust instrument limited the powers and duties of the Secretary-Treasurer and the bylaws required the contract to be executed in the name of the President, Vice President, or trustees, the trust was held to be bound by an oil drilling contract executed by the Secretary-Treasurer, where it was shown that he acted as a general manager of the trust and that the other trustees knew of the fact and acquiesced therein. So this is important right here. If you understand the office of what a secretary and treasurer is, right? These are, for the most part, ministerial duties, right? They don't really make decision-making powers. But he acted with other powers, as if he had other powers. And that's how he got hit. You have to understand the powers within that office before you do, you know. I think I went further than what I wanted to read. I just kept on going. How much more? Yeah, I'm gonna. Oh no, it does go right there to page 90. I'm gonna keep going though. It's gonna be more than an hour. I guarantee it. Now I'm gonna go to this section. Then I'm gonna start a new video, right? So section 53, knowledge or dereliction of trustees as imputable to trust. The knowledge and inaction of the very trustees whose wrongful acts constitute the basis of a suit by other trustees cannot be relied upon as laches barring such suit, nor do knowledge acquired by shareholders prior to the election as trustees and their inactions prior to that time constitute such laches as would preclude them after their election as trustees from maintaining an action on behalf of the trust estate. And the trust has been held not to be charged with the knowledge of a trustee with respect to an unrecorded mortgage on property sold by him to the trust. The right of a trustee to recover as a representative of the shareholders and for their benefit has been held not to be affected by his misconduct or fraud in his individual or private capacity, although the conduct would preclude him from recovering for his own benefit, which should be. footnotes, wherein the court said the doctrine of laches has no application when one goes upon whom the duty of prosecuting the action devolves were themselves the wrongdoers. All right, the other annotations ain't worth much. So this will be the end of this video. So I'm going to start the other one right away. This way this doesn't drag out. So hopefully you guys enjoyed. And like and subscribe to the Butterfly Monkey Trust. And again, I thank anyone who participated in the webinar for tax management for foreign estates and trusts. This week I will be doing elementary law. I already kind of started it. I just haven't posted anything. All right, and that's all. See you soon.